The Sanctuary Doctrine, the Universal Tenant Protection Declaration, forging an untouchable legal fortress against medical discrimination, illegal surveillance, and the abuse of power by subsidized property management and state actors. Primary declarants: Joshua Elijah Ford and the McKinley residents. Jurisdictional context: Federal Civil Rights, FHA, ADA, and Hawaii Revised Statutes, HRS Section 521-74, HRS Section 329. Global application: a precedent-setting mandate for the protection of rent-paying citizens worldwide. Preamble: the right to survival and sanctuary. A domicile is fundamentally designed to serve as a biological, psychological, and economic sanctuary. When a citizen fulfills their legal obligation by paying rent, a legally binding shield is formed around their home. This declaration examines and condemns the severe illegality of asymmetric property management, specifically, the phenomenon wherein property administrators and resident law enforcement weaponize their authority to harass, economically sabotage, and illegally surveil higher-paying apartment tenants. By synthesizing federal fair housing mandates, civil tort law, reasonable accommodation doctrines, and constitutional protections, this document establishes a definitive, legally binding boundary. It serves to protect Joshua Elijah Ford, the McKinley residents, and tenants globally against medical discrimination, selective enforcement, and the malicious abuse of judicial processes. Article 1. The breach of quiet enjoyment and the asymmetry of power. In landlord-tenant law universally, the foundational pillar of a lease agreement is the covenant of quiet enjoyment, Restatement 2nd, of Property, 1977. This legally binds the property owner and their agents to ensure the tenant can occupy the premises in absolute peace. A gross disparity of power and ethics occurs when property management personnel, who frequently live in separate, unattached houses on the property while paying significantly lower rent, utilize their positions to harass the McKinley residents and Joshua Elijah Ford. Management possesses no legal right to act as authoritarian wardens over the very tenants whose higher rent funds the community. Repeated harassment constitutes a material breach of contract leading to a legal state of constructive eviction, Shoshinsky 1980, wherein the landlord can be held financially liable for creating a hostile and medically detrimental environment. Article 2. Selective enforcement and medical discrimination. Under the Federal Fair Housing Act, FHA, and the Americans with Disabilities Act, ADA, landlords are strictly prohibited from discriminating against tenants based on their medical status, trauma history, or disabilities. 42 U.S.C. Section 3604. The lethal double standard. It is highly illegal for management to aggressively target, legally label, and threaten documented medical patients for utilizing doctor-prescribed, state-sanctioned treatments, while simultaneously ignoring or permitting other tenants to consume highly destructive illicit narcotics, such as methamphetamine. This practice is legally defined as selective enforcement and disparate treatment. Selectively targeting a healing patient while ignoring the community's actual destructive hazards proves animus, malicious intent, in a court of law. Article 3. The federal right to a reasonable accommodation. Under 42 U.S.C. Section 3604, F3b, housing providers are legally mandated to make reasonable accommodations in rules, policies, practices, or services, when necessary to afford a person managing a medical condition equal opportunity to enjoy a dwelling. This declaration formally asserts that the McKinley residents and Joshua Elijah Ford require a peaceful, unharassed environment to administer prescribed health regimens and improve their biological survival rate. Any attempt by management to bypass the federally required interactive process and move straight to punishment is a direct, actionable violation of the FHA. Furthermore, Department of Housing and Urban Development, HUD, guidelines explicitly grant property owners the discretion to retain tenants using medical treatments. Because eviction is discretionary, management's choice to pursue punitive action is an act of willful discrimination, not a federal obligation. Article 4. Invasive surveillance and the amplification of trauma. The targeted installation of security cameras directed behind the declarant's private apartment, or angled into their personal living space, constitutes the civil tort of intrusion upon seclusion. Restatement 2nd, of Torts, Section 652b. For a sole survivor or medical patient, relentless, targeted surveillance is a form of psychological warfare. It does not foster safety. It actively triggers the nervous system, inducing hyperarousal and exacerbating post-traumatic stress disorder, PTSD. By creating a panopticon designed to intimidate, management economically and biologically sabotages the patients, draining the resources they need for healthcare and survival. Article 5. Deprivation of rights under color of law. A citizen's rent money must never underwrite their own harassment. When off-duty or resident police officers utilize their state-granted authority, uniforms, or intimidation tactics to illegally surveil, illegally record, or harass the McKinley residents on behalf of property management, they violate federal law. Under 18 U.S.C. Section 242 and 42 U.S.C. Section 1983, It is a federal offense to deprive any person of their constitutional rights under the color of law. Furthermore, filing or threatening to file unfounded restraining orders to intimidate a medical patient constitutes an abuse of process. Prosser and Keaton, 1984. This malicious tactic actively obstructs the patient's physician from renewing medical cards, acting as an illegal barricade to life-saving healthcare and severing patient-client trust. Article 6. Statutory protection against retaliatory eviction. Pursuant to Hawaii Revised Statutes, HRS Section 521-74, and the Fair Housing Act, 42 U.S.C. Section 3617, it is strictly illegal for a landlord to retaliate against a tenant for asserting their legal rights or complaining about civil rights violations. Any attempt to evict, increase rent, decrease services, or increase surveillance following the submission of this document will be legally presumed as an unlawful retaliatory action, subjecting the landlord, management, and associated agents to severe punitive damages. Article 7. Formal notice of spoliation of evidence. This section serves as a legally binding litigation hold. Property management, landlords, and associated law enforcement are hereby placed on formal notice that they must preserve all evidence related to this community. This includes 1. All audio and video surveillance footage capturing the McKinley residence and Joshua Elijah Ford. 2. All audio and video surveillance footage capturing common areas where illicit narcotics, e.g. methamphetamine, have been consumed, tolerated, or ignored by management. 3. All internal emails, text messages, and written communications between management and/or police regarding the declarants. The intentional destruction, deletion, or alteration of this footage to hide management's selective enforcement or asymmetric surveillance constitutes spoliation of evidence. Should this matter proceed to a judicial body, the court will be instructed to infer that any destroyed evidence contained explicit proof of management's illegal and discriminatory actions. Execution and demand for compliance. This document serves as an impenetrable shield of rights. Joshua Elijah Ford, the McKinley residents, and tenants worldwide possess the absolute, legally defensible right to prioritize their health, utilize their prescribed medical treatments, and exist in their paid dwellings free from state weaponization, hypocritical policy enforcement, and psychological abuse. Management, landlords, and state actors are hereby ordered to cease and desist all targeted harassment, illegal surveillance, labeling, and legal threats immediately. Signed and declared, Joshua Elijah Ford. The McKinley residents. References and legal precedents. Americans with Disabilities Act of 1990 42 U.S.C. Section 12101, et seq. Civil Action for Deprivation of Rights, 42 U.S.C. Section 1983. Deprivation of Rights under Color of Law, 18 U.S.C. Section 242. Fair Housing Act, 42 U.S.C. Section 3601, et seq. Mandating reasonable accommodations and prohibiting retaliation. Hawaii Revised Statutes, HRS, Section 521-74, Protection against retaliatory evictions. Hawaii Revised Statutes, HRS, Section 329, Uniform Controlled Substances Act / medical use of cannabis. Katz v. United States, 389 U.S. 347, 1967. Establishing the reasonable expectation of privacy. Prosser, W.L., and Keaton, W.P., 1984. Prosser and Keaton on the Law of Torts. Defining abuse of process. Restatement, 2nd, of property. Landlord and tenant. 1977. Defining the covenant of quiet enjoyment. Restatement, 2nd, of torts, Section 652B. 1977. Defining intrusion upon seclusion, invasion of privacy. Shoshinsky, R.S., 1980. American Law of Landlord and Tenant. Defining constructive eviction.